Please the court, my name is Matthew Atkinson. I'm the attorney for the respondents and cross appellants Switzgable and Brown. The characterization of this case is somehow the interest of the seashore against the town, I believe, mischaracterizes it. The town is not monolithic, Brookhaven. It has numerous departments, and in cooperation with the federal government, it decided...
The problem, if I could interrupt, the problem, the initial hurdle that you face is the warning by the Court of Appeals repeatedly given about how courts should be very, very cautious in interfering with determinations made by zoning boards of appeal. And the issue really here, I guess, is whether this is one of those very few cases in which the court should have, and it did, or whether we should overrule the judgment of a BZA to annul a grant of an area variance. That's quite a hurdle that faces us in virtually every case. Wouldn't you agree with that?
Well, I fully agree with that. I'm well aware of the way the law is, but the Court of Appeals is not saying that these area variances are not reviewable. They certainly are, subject to judicial review. And this is a case where it is evident that the Zoning Board of Appeals, or the BZA in this case for Brookhaven, did not apply the state balancing test, and that is absolutely required. What it simply did was it said, okay, he wants these variances. It's sort of consistent with the neighborhood. I'm not asking this court to investigate these facts. Even if it is consistent with the neighborhood, there's nothing in their decision and nowhere in the record that indicates whether these consistent, lot exceedances, for example.
They didn't do a balancing test at all of them, is that right?
No. Everything was a feather, and they just, what was determinative was, this is what he wants, this is what we're going to give him.
So your position is not that we ought to review the conclusion they reached so much as we ought to review your contention that they didn't perform the function that they are required to perform.
Absolutely.
And if you're right, do we send it back for a remand for them to consider that, or do we absolutely give you judgment?
We would prefer judgment, certainly, because we don't see how this can balance. You see, we have a federal interest that's been... Sorry.
If they don't do a balancing test at the end of the day, then what they've done is arbitrary and capricious.
That's correct.
And
it's unlawful,
too.
too.
Abuse of discretion, because they can't just sit there and say, well, in this case, we're going to, grant the variance, and we're not going to do what we're supposed to do by balancing.
I guess Justice Bellin answered my question.
Well,
Thank you.
Yeah. Any kind of reasonable application of the balancing test here would take into consideration that this remedial statute to keep lot coverage to 35%.
What do? Do we give them the right or the direction to reach that conclusion first, or do we say you didn't perform your function, you didn't perform the balancing test, and therefore we're going to perform the balancing test?
I think that if this court were to remand it to the Board of Zoning Appeals, it really should do it with very clear instructions that it has to give weight where it gave no weight. And, and in a sense, once you do that kind of balancing, once you give weight to the 35% lot coverage as a finding by the legislative and administrative branches, both the federal government and the town of Brookhaven, which adopted it, if you give weight to that, if you give weight to the fact that these variances are substantial as a matter of law under the case law in New York State, they're not minor variances, they're all substantial. 20% lot coverage, up to 60% on side yards, 70% on the 10-foot wall. These are substantial as a matter of law. And then you take into consider the fact that they're all self-created. To the extent there's any hardship at all, which there isn't, it's simply that the applicant would like this. You take all of that, that's a lot of weight, and you put the feather on the other side, which is the applicant wants it. I don't see that there's any way to balance this any other way. So I think that, indeed, this court could make that decision, but certainly if it remands it, it should be with, clear instructions to follow the applicable law, state law, not federal law.
What did you ask for in your relief here? Did you ask for us to purely to reverse, or in the alternative to remand it back for them to consider the characteristic, the criterion?
We asked that for the court to reverse and to vacate the granted variances, and in the alternative, yes, to remand with instructions. I mean, it's really important, I think, to realize that when we're talking about what the board did, that it doesn't look to see whether any of the variances that it granted are for grandfathered, fixing anything. It doesn't care. It doesn't even care if they're legal or illegal. For example, the only wall that it found comparable to the 10-foot privacy wall that the applicant was seeking was one on the opposite side of the property, where the uncontradicted testimony was that this had been constructed by the applicant illegally. I mean, how can this, act as precedent for the board, even under their own rules? Furthermore, it is true, as you were pointing out, Justice Leventhal.
I just ask questions. I don't point.
Well, there was some confusion because the Department of Environmental Protection was objecting to these variances as bad for the island. And it wasn't just the seashore. It was the own interior, advisory body that was also disregarded by the BZA. So as far as the conflicts go, we make no allegation because we don't know. But we briefed it. He raised it. He opened the door. He needs to walk through and tell us what's going on or recuse himself. And he is the chair of the board. And he absolutely shepherded this through. And it's not as though the vote would have been the same with or without him. We don't know that. Similarly, the violation of the Opens Meetings Law, which is connected to that we've alleged, I've briefed, and I won't belabor that point.
Thank you, sir.
Your Honor, just the
A
factual...
statement of fact?
Yes, statement of fact, Your Honor.
Go ahead.
In regard to what my adversary made a comment that the Department of Environmental Protection appeared or made some presentation... Objection to...
They sent a letter.
To the application.
They sent the letter.
The letter was sent after the record was closed in the BZA hearing, and it
Okay.
should not be held.
Thank you. Case number 14.